Good morning and welcome to today's CLE training. Thank you so much for joining us. Today we are conducting a training that is aimed to equip lawyers on the protection of land rights for communities that are affected by mining and agricultural practices. And our training will be led by Professor Christopher Mbazira. If you have not yet done so, please ensure that you complete the pre-training survey. So the pre-training survey can be found in the chat. There is a pinned link that you will see that you can follow, and then you can complete the very short and simple survey. And kindly note that this pre-training survey is a requirement from the Law Council. So please be sure to do this, especially if you are seeking to earn CLE points through today's training. All right, as everyone completes the pre-training evaluation, allow me to give some opening remarks on behalf of FIDA-Uganda. And so today is the seventh CLE training in our series for 2024. And we are very close to the end, as we only plan one more training that will be running next month. We rolled out our first CLE training series in July of 2023. And then we also ran 8 trainings over the course of that year. FIDA-Uganda is a professional membership organization, and we are charged with the responsibility to promote the professional development of female lawyers through training, mentorship, capacity building, the creation of networking opportunities, and the convening of policy advisory spaces to enhance access to justice and women's empowerment. The Academy draws on the organization's 50 years of existence and leverages our membership's wealth of experience from the diverse backgrounds and positions that we occupy in order to propagate knowledge and best practices among female lawyers in Uganda. FIDA-Uganda, through our Leadership Academy, is accredited by the Uganda Law Council as a provider of continuing legal education, and we offer CLE courses to train legal practitioners on gender, legal aid, service provision, feminist lawyering, and the application of regional and international instruments to advance gender-responsive litigation. All of our CLE courses are led by experts in their respective fields, including accomplished attorneys, legal scholars, and industry specialists. Today is absolutely no exception, and we are honored to have Professor Christopher Mbazira, who will be leading the training for us. And so Prof. Chris Mbazira is a professor of law and the coordinator of the Public Interest Law Clinic, PILAC, at Makerere University. He is also a founding member of the Network of Public Interest Lawyers, known as NETPL, and he previously chaired the Rule of Law Committee of the Uganda Law Society. Since 2018, Prof. Mbazira has supported the National Planning Authority in integrating the human rights-based approach in the country's development agenda. Prof. Mbazira has consulted with international agencies, including the United Nations, on human rights and governance matters. In 2021, Prof. Mbazira won the Uganda Law Society Award for his distinguished services in legal education in Uganda. Prof. Mbazira has been key in introducing the use of Prof. Mbazira has been key in introducing the use of clinical methodology of teaching law and building a community of public interest lawyers in Uganda. Prof. Mbazira holds an LLB from Makerere University and an LLM in human rights from the University of Pretoria. He also holds a PhD from the University of the Western Cape in South Africa. Prof. Mbazira has published extensively on the topic of the protection of land rights in the context of agricultural, mining, and other business enterprises. We know that the lives of countless Ugandans and Ugandan communities are affected through the expansion of business enterprises. And while the economic growth of the country is welcomed, the human cost has to be counted. As FIDA, we also know that the gender dimension of the impact of mining and agricultural activities are often hidden and can go unaddressed in processes that do exist to ensure compensation to communities. We believe that today's training will enable us as human rights lawyers to have a bigger toolbox in respect of how we can use litigation to protect the rights of communities who are affected by mining and agricultural activities. So at this point, I would like to invite Prof. Chris to lead the way for us. Alice, if you can kindly display Professor Chris's PowerPoint, that will be really helpful. Yeah. And also a very last reminder, if you have not yet completed the pre-training evaluation, please do that now. The pre-training evaluation can be found in the chat. There is a link that will take you to a Google form, and it's just a few questions. So please, if you've not yet done that, be sure to complete that pre-training survey now.
Yes, Lynette, just give me a minute and I'll display it.
Lynette, is it possible that I'm given sharing rates so that I'm able to scroll the PowerPoint myself?
Yes, we can do that. That might be, more effective.
Yeah.
As we to sort out this small tech glitch, and to our participants, kindly also take note that we are using our new method of training. And for the past, well, I would say for the first five trainings for this year, what we have done is that there will be 5 hours of teaching and group work. But today we are doing it a little bit differently. Prof. Mbazira's presentation and teaching will go up to 11 a.m., after which you will receive a take-home assignment that you will have up to 3 p.m. today to submit to us at FIDA Uganda. So we will not be using the entire 5 hours for training, and some of this time will go towards actually completing an assignment on your own and submitting it by the 3 p.m. deadline. So please take note of that, though I will definitely repeat it again at a later stage in the training. And so it seems that Professor Mbazira is all set and we are ready to start. Chris, thank you. Over to you.
All right, thank you so much. Let me just change the format of the, just give me a minute. I was said that then I saw that the format was not what I wanted it to be. Let me change something, sorry. Okay, I hope I'm able to scroll. Lynette, my apologies, I'm not so familiar with Google Meet.
Okay,
So
sorry about that.
I'm trying to check where I can scroll. Let me see if I scroll in the main, whether it scrolls. Just check on that. Yes, okay, I got it.
Excellent, excellent. Thank you.
I got it now. Okay, good morning, colleagues. It's my pleasure to be here. Thank you so much, FIDA, for organizing this and for trusting me to deliver this. It's always a learning for me as well. So I'm hoping to learn quite a lot from the colleagues here. I'm going to try to be as slow as possible, and will be guided by the PowerPoint that I've shared. We may veer away from it, of course, if the need arises. Please feel free to stop me anytime if you have a question, if you have a comment. I think I'll do like 45 minutes to 50 minutes, then we can have a short pause and then we resume. Thank you so much, Lynette, for the generous introduction. So I was asked by FIDA to facilitate this CLE, which is looking at protection of land rights of community affected by agriculture and mining activities in Uganda. It is very relevant to our context now. I think land has become one of the areas of big conflicts, violence, not only at a macro but also micro levels. We see that between communities and the state, between communities and individuals, between nationals and non-nationals, between nationals and multinational corporations. It's just a mix of so many conflicts around land, some of which have escalated into violence, and it's getting worse by the day. So it's a relevant subject. Thank you, FIDA, for choosing this. I hope we can make this even broader so that we go deeper into how to deal with protection of land rights. But it's also controversial at the international level whether there is actually such a right as land. So what I'm going to do for this presentation, I'm going to look at the context of land rights. I would like to look at using litigation in the context of public interest litigation. So I'll look at definitions, but of course we shall also discuss other forms of litigation, and then look at history of this form of litigation, the context in Uganda, which also includes the legal framework, and then the future, and maybe say something about how we can concretely use this to litigate the right to protect the right to land. That's the outline that I'm going to follow. I want to begin with this quote by Rousseau, where he says, I quote, "You forget that the fruits belong to all, and that the land belongs to no one." It's a loaded statement. It's looking at the fruits of land, and it is saying that these fruits actually belong to all of us. So meaning that all of us as part of humanity are entitled to the fruits, of land. But it's also reminding us that actually land does not belong to anyone. Meaning again, it belongs to all of us and it belongs to no one. That's the interesting thing. And this is what it has been, or this is what it should naturally be. Unfortunately, as we shall see, this is not the case. Is that land has been commodified, land has been individualized, land has been commercialized, land has been taken from the realm of communal property to the realm of individual property. Land has been sucked into the capitalistic system of production, which is based on survival for the fittest, sort of, and it is based on the principles of exclusion of the weak and those that are considered to be, lazy and not committed to work and things like that. So we need to see how do we restore this statement that actually land belongs to no one. And this is where litigation could play a role, because as lawyers, litigation is what we know best. Now, the benefits of land are innumerable. what I've put here are just examples of what we use land for. But land is indispensable to life. Land is indispensable to humanity. Land is indispensable. We can't do without land. And these are some of the things that we use land for. We produce food on land, so meaning we can't survive because we need food to survive. We live on land. The housing that we use, the shelter that we use is constructed on land. We extract natural resources, including medicines, from land. So without land, we cannot access medicines or other resources that we use for other purposes. So for medicines, our health will deteriorate. It is on land that we bond as communities and families. You know, for many Ugandans, as the culture here is, every end of year, December, Christmas, most of us drive out of town and go to bond with communities, go to bond with families, and this happens on land. We reproduce on land. We reproduce on land. I'm not aware of any person that was born in the air, but we reproduce on land. Even those activities that result into pregnancies and stuff also happen on land. Our remains waste away on land. We are buried on land. Even those who are cremated, eventually the ashes are sprayed on water, which is part of land, or they are buried or put somewhere on land. We nurture other creatures that from which we derive livelihood and sustenance on land. Cattle keepers do so on land. People engaged in piggery or domestication of other animals that do it on land. We exercise spirituality on land. Some people exercise spirituality by worshiping trees, others by worshiping rocks, others by going to churches which are built on land, depending on churches and mosques which are built on land, depending on one's spiritual commitments. We travel. It's on land that we are able to move from one place to another, and in the travel we accomplish so many things. So you can see that without land we can't accomplish these things, and it means that our survival and our existence as human beings would actually be challenged. So that's why it is important that we understand the relevance of protecting the right to land. Communities have gone into oblivion when land is taken away. Communities, ethnic groups have gone into extinction when land is taken away. In the case of Uganda, we see, for instance, the Batwa people almost going into extinction because they were deprived of their land as a result of conservation. We've seen communities that have wasted away because of hunger and famine, where the land is taken or where the land is no longer productive. So if there is anything that we should fight to protect, it should actually be land. Land should be one of the most important rights that we should prioritize when it comes to protecting human rights. Yes, we may have civil liberties, we may protect our democracy, but if we eventually achieve this and the land is gone, it becomes a problem. Of course, we can use those freedoms to claim the land back, but land is key. And we need to invest a lot in protecting land. Before I proceed, I just want to be sure you hear me.
Yes, we do.
Okay.
We hear you very well.
Okay. Thank you. So those are the uses of land, but unfortunately, we are faced with a phenomenon of land grabbing. You know, land grabbing is on the rise. Every now and again, we see in the news massive evictions, entire villages evicted. Once now and again, we see in the news a family being disposed of land. We see a widow being disposed of land. We see an army general using the gun to evict people. We see bulldozers, as we see in that photograph, within days or hours, actually within hours and minutes, erasing people's houses and changing the use of the land. And the phenomenon of land grabbing is not only Ugandan, it's actually a global phenomenon which has happened as the demand for land increases, because the demand for land has progressively increased and it never ceases. Actually, every year it gets worse as more people are looking for land. Of course, the population is also increasing. As much as we still doubt the statistics which was given by UBOS, we say that our population has increased, but I disagree with UBOS. I don't think we only 45 million. I think our census report has so many gaps, but nonetheless, the population has increased. Of course, remember UBOS, it first began by lying to us that certain tribes have had their populations decrease. But globally, the world population is increasing. As the world population increases, we need more food, and food is produced on land. So you see a craze to get access to land. We need biofuels because as the prices of petroleum products, including petrol and diesel, went up, people started innovating with other fuels, and then it was discovered, I think, most prominently in Brazil, but it's now common in the US, Europe, that you can actually produce fuels from certain crops, including maize corn. You can produce fuel from maize corn, you can produce ethanol from sugarcane, and there are multinational corporations that are now growing those products like palms globally for the purposes of biofuels, and they need land to do that. But we've also seen the rush to get land fueled by finance, and this is connected to the 2018 global financial crisis. I don't know if anyone remembers. Does anyone here remember what happened in 2008? Sorry, not 20, it's 2007, 2008. Anyone that could share with us?
There was a big economic crash.
Yes. Do we remember what caused it?
Excessive lending or excessive borrowing.
Yes, excessive lending, excessive borrowing, especially for housing purposes in the US. And then, of course, the connection of the financial system, that the US financial system is connected to financial systems elsewhere. These banks are connected, they are the same. So the mortgage market collapsed. When it collapsed, it had a ripple effect. And what that did is that it made investment of capital risky, because in an instant you could lose your capital. So for smart investors that had money, it became safer to invest money in land. So there was a rush to look for land to invest that money in. We could see a repeat of that again when we see what are they called? What bitcoins and stuff like that. I've forgotten the technical word. Again, we see people investing a lot in that. We've seen crashes. So increasingly, it has become established that it is safer to invest in land. And we see that not only at a global level, but even at a national level. Every person here, including people on this in this training here, when they make money, the first thing they think about is, let me buy some land. Let me keep some money, some of my money in land. Lynette, I know that down south where you come from, it's always housing, but it's also land. Everybody whose salary increases now thinks of taking out a mortgage or getting a bigger house, and all this is land. We've also seen a rush for land for purposes of extraction of oil and gas. again in Uganda, that's alive to us in the Albertine region. We now hear that there is oil and gas elsewhere in the country. We could be, I stay in the Namgongo area. You never know, I could be sitting on oil here. Who knows? 10, 20, 30, 40, 50 years from now, myself or my descendants could be asked to vacate because there is oil and gas and other minerals, of course. Carbon credits have also fueled the praise for land. Anyone that has an idea here what carbon credits are? Sorry, guys, you know I'm a teacher, so I will keep asking the questions. Our teachers, we are like that. We are so bad that even when you appear in court arguing a case, sometimes you forget and you think you are teaching, and then you start asking the judges questions. So anyone that has an idea what carbon credits are? Are we there? Are we there?
I see Susan Baluka on the call. I have a feeling that she's going to give us a good definition. Susan, do you know what carbon credits are?
Hi, Lynette. I do not know what they are in their entirety, but I know they have something to do with targets that we have with regard to climate resilience, targets that different countries have with regard to meeting their targets for climate resilience.
Yeah, connected to that, climate change, global warming, we've messed the environment. So what rich countries are doing now, they started projects. I think there was an EU project where they were rewarding those who grow trees. You grow trees, you are rewarded, you are given money for every tree that you've grown, or a forest, an artificial forest. So some companies that wanted to benefit from that descended on Africa, Uganda inclusive, to grow trees massively on large acreage. We had such cases in Mayuge, I think. We have had such cases in Chivale, if I'm not mistaken, and other places, and they need land for this. But of course, the trees they grow again are later harvested, but they get credits. In what we mean by credits, they get money for growing those trees because they are managing the effects of global climate change and global warming. Now, recently, we also see the COVID crisis escalating the demand for land. First of all, if you remember, during COVID, we were idle. Most of us were idle. And those of us that had access to land started using our land. And those of us that had the money, I bought land myself, a lot of land during the COVID lockdown because I was idle. I needed land. The land I had was little. Then I could see that I can start farming, and it became a business. I established a farming business, but all this happened after COVID. And what we observe, those of us that have engagements up country, is that after the lockdowns, people now started descending on the villages to buy land because they had seen the value of farming. Because those who had farms and could get food were not badly affected by COVID. So that too has fueled. But what COVID has also done, and we are feeling the effects now, is that COVID has also resulted into a financial crisis of some sort. So we are likely to see, like it was post 2008, a rush to buy land as a safe investment, because during COVID, almost all assets were depreciated, including your money in the bank, and it is continuing to depreciate, but land has not depreciated. Actually, the contrary, land has appreciated. We've also seen conservation taking ground as countries move to get the tourist dollar, You can see Uganda, it's a big thing. We need the tourist dollar. We can't get the tourist dollar unless we've conserved and created game parks and game reserves and protected those that are in existence. We cannot. So there is that rush. Evictions sometimes happen, or places are declared protected areas and people have to leave, sometimes with or without compensation. So that's the craze for land, and it's going to get worse. It's going to get worse. I can predict, most especially because of the current post-COVID economic meltdown that we are experiencing. Now, very quickly, the context in Uganda, because we also need to do what I've just discussed is the global context, but of course, Africa has been the most affected. The context in Uganda is, first of all, that Uganda is blessed by nature. People, I still believe that in terms of nature, of course, we are doing a lot to damage the nature, but I still believe that in terms of nature, Uganda is the best country in the world. And I speak this because I've traveled. Forget about the skyscrapers in New York, the extensive road infrastructure in South Africa. Forget about that. The beautiful beaches in Miami. Forget about that. But nature generally, I think Uganda is the most endowed, even in the region here. Imagine a country where you have sometimes 3 rainy seasons in a year. Imagine a country where almost 80% of the country is permanently green. From January to December. Imagine a country where people can grow food for decades on the soil without adding any fertilizers, but they still get yields. That's what Uganda is. Imagine a country that has so many water bodies that never dry up. Sometimes, of course, the water levels reduces, but never dries up. Like right now, Zambia, since the beginning of the year, has not had any rains, and they are facing a serious water crisis. The hydroelectric dam has dried down, and they now have load shedding sometimes for a week without power. We don't see that in Uganda. So we still remain the pearl of Africa. We have the best soils, I think, in the region. Whether we are utilizing the soils or not is another thing. So we need to understand that contextual fact about our country. But we also need to understand the context of the historical injustices, especially as far as land is concerned. I need not belabor those 1900 agreement, as you know it, dispossessing people of land and putting large chunks of land in the crown, becoming government land, and then a very big portion of land going to the hereditary chiefs and kings and their cronies. And those injustices we still see with the battles especially in central Uganda between the Bibanja holders and the landowners. Those historical injustices that are not going away. But contextually, we also need to understand that we actually run a broken judicial legal system. To a certain extent, our system is broken. It is not capable of effectively resolving disputes. It is not capable of effectively ensuring access to justice for those who have been deprived of land. We also need to understand the context of direct foreign investment, where Uganda, like many countries, at the compulsion of the World Bank and IMF in the 1980s, 1990s, was forced to open up, to liberalize the economy and open up for direct foreign investment. So we see so many investors coming in. Initially, they were coming in to establish industries. Of course, they need land, but they also came in to engage in mining. There is another form of direct foreign investment which is happening, where foreign investors are coming in to buy land and engage in farming. to buy land and engage in farming. This is happening actually. I have my farming activities in Luweero. Now, increasingly in Luweero, we are seeing so many Chinese buying land. Indians are buying land there and engaging in farming, as well as Kenyans, our brothers from Kenya, brothers and sisters from Kenya are also doing the same. Contextually, we also need to appreciate the government efforts to commodify land, because we've seen government efforts to commodify land by pulling land. The argument is that land has to be brought to the market to enable people use land as collateral. And the commodification has taken the form of individualizing ownership by encouraging communities, individuals to get land titles. Of course, sometimes it is indicated that it's a community getting the title, but in reality, it is not. So all these things have fueled land grabbing, but they also paint the quagmire that we have in Uganda regarding land. Okay, colleagues, are we together?
Yes, we're together.
Yes. I just want to hear from the participants what they have picked up so far from what I've said. Anything that stands out? Lynette, I can't see the screen of participants. You can help me if you can call them
Okay.
out by name. By name.
Okay, let me do that. Okay, Omeka, can you share some, just really what your take is on what we've discussed so far?
I can share what I've got. I just don't want to share and end up asking a question at this point. That's my biggest challenge. But really, from what I've gotten broadly, is just the issues around land. For example, you mentioned on the tenure systems, and how that affects, say, later on when you build. I'm sure you will greatly speak about how the tenure systems are greatly affecting mining. Then I've also picked hints of, the environment and the broader picture of the environment. Then you've shared also on, not directly, but you've shared on like the global perspective, what's happening in other countries and what's happening here and things like that. So I don't know if I can ask now, but I'm hoping I can ask later. But these are the hints that I get: tenure, global systems, the environment, the carbon, I forget the other word for it, but what I was sharing about, yeah.
Sure, you can ask.
I can ask. There are just a huge array of questions, but let me ask. So my first question would be, our mining, the way mining is regulated in this country, maybe you can correct me if I'm wrong, but from what I remember in school is that when a mineral is found, it belongs to the government, right?
Yeah.
Yeah, when a mineral is found, it belongs to the government. But then if the mineral is sitting on your land and you have ownership of that land, you should have some sort of entitlement to that mineral. I know in America, that's the standard. And then again, if you saw in the newspapers, I think not so long ago, there was a foreigner who was duped of gold, something like that in the newspapers. So the government is saying that these resources are actually they're resources for the nations, but yet you can actually see some people actively engaging in what? In owning these minerals in their individual capacities. So what's the disconnect there? What is not happening? Then I know Pastor Kakande has licenses to mine. So I don't know the whole concept of what mineral exploitation in this country means in relation to everyone having an equal share. Yeah. Then the other question that I would have is on the land tenure systems. So our land tenure systems, are they really going to work? Because personally, I don't have hope in them. You have land tenure systems that are cultural. You have the Milo tenure. You have the freehold tenure. So everyone is just sort of, it's like a laissez-faire system, right? So if any regulation becomes impossible, I don't know what the position was in the meantime, but it was sort of leasehold. So is that a place that we would want to go back as a country? Because now mining is not going to stop. Exploitation of land is not going to stop. But if we continue with the tenure systems that we have, the rich are going to get richer, while the poor are going to just keep getting poor. The other one is land use vis-a-vis population growth. The population just keeps increasing and increasing, and we are becoming more and more. The land is not becoming, it's not growing as in relation to that. Elon Musk may have dreams of conquering space and moving some of us there, but what's that relationship like? Land use in relation to the way the population is growing. But I think for now that really is it. Then even in relation, just the last question that I would have is on decentralization. So the government says that they're employing this whole decentralization model that is going to help people bring services closer to the people. But in the decentralization model, the local government units seem to have power except over their own resources. So they're supposed to remit whatever little money that they have back to the government. I know this sort of goes away from mining, but again, it sort of relates because then they don't really have any power. So what does that look like? But my biggest questions would be on tenure, and then they would be on that the who benefits from the mineral in this country. Is it the rich? Every day you open a newspaper, someone is duped of a gold piece. Then land use in relation to population growth. And yeah, for now, that's it.
Okay, thank you. All right, let me quickly respond to those questions. I'll try. Any other person can also give their views on the first question regarding rights. In mining law, they are what are called surface rights. They are surface rights. So even if there are minerals under your property, your land, you have the surface rights to use the land for farming, to use the land for housing, to use the land for grazing, and other uses that can be done on the surface. And the state cannot extinguish those surface rights without compensation. So that's why the people in Bulisa and elsewhere that government has discovered oil are usually compensated. Government is supposed to compensate the persons for the surface rights. But at the same time, any person under the mining law has a right to engage in mining, but that requires a license. That requires a license that should be issued by the government, because as a principle, the minerals are owned by government in trust for the people, but the government has the right to allow others to actually use the land. I mean, get access to the minerals if there is a license. But of course, whether those licenses are issued in a proper way, that's another question. Whether everybody that is engaged in mining has a license, that's another question. It may not be the case that everybody that is engaging in mining has a license. Regarding the tenure systems, that's a very big problem that we are sitting with. And partly, in my view, that problem was caused by the introduction of the torrent system. If you remember, the torrent system as represented by the Registration of Titles Act, by the torrent system, which brought something from Australia where property was individualistic and brought it here because the colonial state had its own agenda of grabbing land, but also rewarding its cronies, and then they bring the torrent system. And what the torrent system did is that land that was communal, land that was held by leaders in trust for the benefit of the community, was overnight turned into individual properties. And that's what we are sitting with. Even in places where land has previously been communal, gradual, as I said, we see that land is slowly being sucked into the torrent system by people getting freehold titles. Idi Amin was land was owned by the state by the Land Reform Decree, I think of 1972, if I'm not mistaken. And whoever wanted the land would actually get the land as a lease from the state. But 1995 we reverted to that somehow the tenure system that we have. On the increase of the population, very true. But for me, the problem right now is not that we are so many. To me, the problem right now is equity in land ownership and distribution. Why should you have 10 million landless people in the country, and yet you have individuals that own square miles of land? One individual owning 10 square miles of land, and then others don't have land at all. So to me, I think the surface of the earth right now is big enough for all of us if there is equity. Of course, but it also calls for efficient use of land. Some countries are already doing that, even in our neighborhood here. For instance, I know that in TZ, you can't construct in the city area and construct a bungalow in certain locations. It has to be storage. That's effective use of land. On decentralization, I agree with you. Let me now move on, because I see the way time is running. That time can really run. So in the process of land grabbing, we see so many rights violated. We've seen so many rights violated, including adequate food and nutrition. People's gardens are taken away, rights to adequate housing. Remember what happened in FIDA-UG, in Uganda, here in Nansana. Rights to a family, families are dispersed. They are forced to scatter. We've even had cases where some people are killed. Cultural heritage is disrupted because some people have cultural sites on the land. Human dignity is disrupted. What's the human dignity of this lady? Do you remember this photograph? This photograph here. What happened in FIDA-UG? You can see the dignity of this woman taken out. All she owns now is a chicken. Liberty and due process, people arrested and prosecuted for criminal trespass on land, for resisting the officers of the law, for disobeying lawful orders during evictions. All those are violations of rights. Now, land disputes are common. Here, the Hague Institute for Innovation of Law did the survey. I think this was in 2022, if I'm not mistaken. And it shows that actually land disputes are the most rampant in Uganda. And it says that actually 70% of people that had disputes in Uganda, 70% of those disputes were connected to land. Then it breaks down the common land problems or disputes. It shows disputes over boundaries, over use of land, over land titles and ownership, eviction. As much as eviction covers only 14%, but sometimes it affects a substantial number of people when you look at the numbers of people that are involved. The question then is, can we protect land rights using litigation as a tool? Can we protect land rights using litigation as a tool? Definitely, the answer is we can. We can protect land rights and use litigation as a tool. Why can we use litigation? What are the benefits of using litigation? They are numerous. We know that litigation clarifies the law. We know that we can use litigation to stop violations and abuses by getting injunctions, injuncting certain actions. We know that we can use litigation to give victims relief, victims of evictions, victims of land grabbing, persons whose property has been destroyed. We can use litigations to create jurisprudence which can be used for multiple purposes. Jurisprudence can be used for teaching, it can be used for law reform, it can be used in litigation itself to grow additional jurisprudence. We can also use litigation as a tool to empower communities, where communities are empowered to know that they can actually use the law to seek relief, to get remedies. we can't use litigation for those purposes. But when you use litigation, what do you want to achieve? That's a key question, because we are now strategizing how to use the litigation. It is very important to determine your intention, and you must be deliberate and intention. In other words, if I can use the colloquial local term, we don't litigate far. We don't litigate far. Our litigation must be intentional. Our litigation must be purposeful. Our litigation must be guided by proper doctrines. Our litigation must be guided by a clear agenda, what we want to achieve. So it has to be calculative, it has to be intentional. And I want to put before you, if your litigation is going to be intentional, if you are going to litigate for land rights, you have to make a choice. And I want to put before you two broad strategic approaches from which one can choose rather. You can aim your litigation to target corrective justice, or you can aim your litigation to achieve distributive justice. You can aim your litigation to achieve one of those. Any ideas what these are? Any ideas what these are?
This is a question that definitely needs an answer.
Mm.
And so just to summarize, that you're saying what are the two main approaches to litigation for land rights?
Yeah.
Okay. From our audience, I feel I don't want to call on people if there are someone who can offer an answer.
Okay.
So is there anyone that can share? Emeka, and I'm pretty sure Joy, Elizabeth, Susan, we would really love to hear from you.
So for corrective justice, when it comes to corrective justice, I think it's where an injustice has been suffered and you're trying to remedy it. So for instance, land has been grabbed or taken away from someone to whom it rightfully belongs. So how do you use the law to remedy, to put things back in the state that they actually should have been? That's what I understand by corrective justice.
Yeah, sure. That's one of the elements. One of the elements. Nice try. Any other? How about distributive justice? Elizabeth, was that Elizabeth?
Joy's hands is up.
Good morning, Lynette. I think for corrective justice is majorly holding the multinationals, the people that have perpetrated these wrongs accountable, while redistributive justice is on majorly, I think, trying to address the inequalities, redistributing the resources majorly. I think for me that would be what the difference between the two of them. One is accountability, the other one is more on redistribution. But maybe before that professor goes off, I had a question on when he talked about the torrent system. I know this CLE also should be in line with feminist economics, feminist politics, and all this. So I wanted to ask the torrent system and social reproduction, how do we get to reconcile the same? Because I feel like the torrent system pushes women at the back, because we are usually the ones under the one undertaking care work, and the one at the back of the system. But when we have registration of titles, it's a system that is more capitalistic and doesn't really favor women who are usually on the periphery of the economy. So I wanted to maybe hear you on that. How do we get to reconcile the torrent system, but also have it more femicized in the process, instead of just having a system that is more capitalistic, that doesn't speak of the ideals of women in the society, but also the ideal of social reproduction under feminist economics. Thank you.
Yeah, sure. First of all, nice try on corrective and distributive justice, which I've seen. On the torrent system, I agree that women are the most affected, because even when you look at our succession cultures, it's always the male that are either elected or selected to be heirs or administrators or holders of letters or probate, and usually the land is registered in their names. But even as beneficiaries of estates, when it comes to land, it's always men that are given the land. So it is always the men, even for families, even when there are females in the family, both mother and daughters, when land is bought, most of the time it is registered either in the names of the father, who is a man, or in the names of the father and the sons. So if land then becomes a commodity for accessing capital, it means women have limited access to capital because they don't have the collateral. So we really need to, for me, the torrent system, I don't know how it can be reformed, but we need to reform it first of all in some respects to revert to the customary systems of land. But we also have to ensure that it is equitable. And of course, in the current law, there are some provisions there that make it, that bring in some equity. For instance, provisions that protect the marital property and ensure that women too have access to marital property. It cannot be mortgaged, for instance, without consent, but nevertheless, we know that women are manipulated. I've handled some cases where the woman says, I signed that consent, but he threatened to beat me if I don't sign the consent, or he threatened never to take care of me. So there are those dynamics as well. All right, any last attempt to distinguish corrective and distributive justice? Okay. Now, corrective justice, I think the person who talked first, I've forgotten the name, said it is justice that corrects what has what has gone wrong. Indeed, that's what it is. It rectifies. It has a rectifying role, and its purpose is to put the person, and it's one thing we should know about corrective justice, that it's interested in individual rights, and its purpose is to put the individual who has suffered damage in the position he or she would have been had the violation not occurred. And you know, it emphasizes compensation, equality of parties to a litigation, and the main object, as I said, is to put parties to the position they would have been had the violation not occurred. It is individual in the sense that if my land has been taken away, I can approach court. If there is a massive eviction, if I've suffered and my house has been pulled down, I can take up an action in court for trespass on land, for expropriation without compensation as an individual, and seek individual remedies in the form of damages or other form of relief. In comparison, distributive justice is concerned with the distribution of benefits and burdens among members of a given group. So distributive justice is concerned more with the holistic picture. How do we deal with the holistic picture? If there is an eviction affecting thousands or hundreds of people, how do we address that eviction in a way that everybody is going to benefit, and in a way that this eviction or eviction actions of the like are not going to take place again? When we litigate, how do we also get relief that can be used for the future? That's how distributive justice works. It is broader, not individualistic. And it, yes, tries to give people relief, but it's more interest directed at the future and avoiding similar occurrences. But it also tries to maximize the benefits of litigation in the sense that you don't focus only on the people before you, but you also focus on others that are similarly affected right now, or that may similarly be affected in the future. So that's why I asked them, if we are going to litigate, what form of justice do we want to pursue in our litigation? Because our choice of justice then determines, one, the kinds of clients we represent, but it also determines the types of cases and legal procedures that we use to address cases of violation of property, land rights, including land evictions. So from what I've explained, any views on the form of justice that would be most effective? Any views?
I'll go first while others also share their opinions. So I'm thinking that corrective justice, it's easier to actually ensure that, because you see, oh, there was a violation, there's a specific person, but let's, like, I think because your aim is much smaller and much more contained, it might seem like a more achievable goal and something that, a court could also say, okay, but this is the simple order I should make. And that's already complex enough, I'm sure. But then when it comes to really compensating the entire community, thinking of the broader family, the historical implications, like, I think that becomes a very complex task for the court, even though if you do it right, it will be much more effective. And yeah, would be very glad to hear other views. And I see Victoria Kim on the call. Elizabeth, do you have any views on this? Susan?
Hello.
Omeka, you're the one.
I've been having my hand raised, but Alice's hand is also raised, but I can share what the approach that I think would be most appropriate for me would be distributive justice. The words, I don't know if they're tongue twister or if they're just new to me, but distributive justice, because if we are looking at mining and agriculture, mining has been around for some time, and yet it is still an emerging sort of field. It is still something that we are sort of still trying to regulate, see, not everyone knows about it. So I would pick distributive justice, because now you're looking at allocating resources fairly among members of the society. So the mining sector, how are we making sure that, everyone is sort of benefiting from it, whether you're wealthy, whether you have a lot of money, whether your social status is this and that, even agriculture, even as those two topics relate to things like land and tenure once again. But my answer for that would be distributive justice, that the litigation we should do should be broad in that sense. But I really agree with Lynette that it could be complex. Yeah.
And Alice, please also share your views. Sorry, I missed your hand earlier.
Okay, thank you very much, Lynette. So for me, my take is that it's actually a take and also a question. I feel that both work hand in hand, because if you have, mining taking place, and then you look at aspects of correct justice, you see that you're actually able to have particular precedents that are set out by even like the cases that you're handling, such that there is a fear, even in top companies, in how they do their mining work and all that. And so you kind of create a justice mechanism such that even when they're doing mining work, they are kind of conscious for the communities that are actually around them. But then when we look at also distributive justice, I feel that it will help, such that when they're allocating resources, like everyone in the community is able to actually have like a beautiful share in all that is actually being granted. So for me, it's actually a take on when we're actually advocating for this and doing litigation in this regard. Is there a possibility to have these two run hand in hand? Because I feel like it actually be a better solution. Yeah. Thank you.
Okay. Thank you. Interesting submissions indeed. I really wanted to know whether we've understood what I was talking about, and I'm confident we did, because what corrective justice does, it's very individualistic, just as Lynette said. Then you look out for those, but it's simpler, but at the same time, it's not so effective where there are rampant violations affecting a wide group of people. And when you look at most of the land problems that we have connected to mining and agriculture, it's always affecting thousands, hundreds of community members. So if you decide to do individual suits for each of the affected persons, so for instance, if there is an eviction as is in some parts of the Albertine, and an entire village is evicted, a village that has, let's say, 4,000 people with different interests, it becomes very complex for you to say you are going to litigate for each of those persons. Of course, I'm aware you can do representative suits, but it also has its complexities. So in some cases, we may want to look at distributive justice. But I agree with the person that spoke last to say, who was the question whether we can combine the two. It is actually it's actually possible that the two can be combined, where you are looking at systematic remedies, but at the same time, you're also asking for instance, compensation, or you are asking for some restorative orders or directives that will put people to the position they would have been as practically as possible had the violation not occurred. It's a bit complex for me to go into the nitty-gritties of each of these two. Otherwise, I will just spend time on those. But the desire to litigate cases of mass violations or mass evictions, for instance, or mass grabbing, is one of the things that motivate us to use public interest litigation. Because public interest litigation then is looking at the broader picture. You want to stop a violation once and for all. But this is not to say, and I need to be clear here, this is not to say that you cannot do individual cases. You can actually do individual cases for those that have cases that can merit as individual cases if you have the capacity to. But at the same time, you can also do public interest litigation for purposes of distributive justice. Sometimes the capacity is so limited to do individual cases that what is feasible is actually to do a broader public interest litigation case. That's where at this juncture I now want to say something about public interest litigation. I'm going to rush through this quickly because there is something important that I want us to cover before we run out of time, because I see we have 50 minutes left. So we know public interest litigation. I've seen the people here. I know some of you, you've interfaced with it. I'm not going to belabor so much on the basics, but we know it is that form of litigation by a public spirited person for the enforcement of constitutional and legal rights of those who are socially or economically backward and who cannot approach the court of law for relief. So it's mainly looking at the vulnerable, those that may not have the capacity to retain a lawyer, because if you go corrective, you need to retain a lawyer. And as much as legal aid can be used, easily available. And now, especially now, you know what is happening in the sector. Those of you that are in legal aid, there is no funding in the sector. So if you are going to represent marginalized and economically disadvantaged persons, then appeal may be appealing, because the suit will then not be individual. It may not require much in terms of resources. It may not require a private lawyer. It may require a public lawyer who does it pro bono. So that's why in some cases we prefer to use PIL. Now, what does PIL do? The objects of PIL here are to challenge unfair legislative provisions. So, for instance, if we see provisions in the Mining Act, for example, there are provisions in the oil and petroleum-related acts that we could challenge that are facilitating. Their provisions regarding licensing. If there are provisions we think are perpetrating land grabbing, for instance, or depriving local landowners of benefits or making it easier for them to be evicted, then we can challenge those provisions. But public interest litigation also stops marginalization of groups, in the sense that, if a group has been pushed to the periphery, for instance, by being deprived access to land, when you litigate and bring that group to conceptualize the case, you now pull them and bring them into mainstream discourses. When they appear in court, they become part of mainstream discourses, even those that have previously not attracted attention. For instance, if you litigate, they attract media attention, which reduces their marginalization. It also helps in dealing with impunity, where there is impunity, especially on a large scale, that has become structural. It can challenge state action that is negative. It can also be used to stop violations, including ongoing violations. I'm going to skip the history of, in this presentation, I would have loved to go through the history of public litigation.
Please don't skip it.
Okay. Sorry?
Please
about
don't
that.
skip it. If you're willing to go through it a little fast, we will be really happy to hear it.
Oh, the history. Okay.
Yes,
Because
please.
let me try to do that quickly, because there is a most important section I want to run through before I run out of time. But my assessment is that public interest litigation was born in the US. It was breastfed in India. It was raised in South Africa. I should have added here that it matured into a young adult in Kenya. I'm looking at Africa. It matured into a young adult in Kenya. It has toured, as a young adult, it has toured some countries on the continent, Uganda inclusive, and now we need to know where it is going to die. Now, in the US, PIL is as old as 1876, where in that case of Gideon, the court allowed somebody to use a letter as a petition. But it mainly grew, or it was mainly reborn in the 1960s and 1970s during the civil rights movement, where political activists, those that were fighting against racial discrimination, started using PIL in addition to other civil actions. So, for instance, we had such organizations as the National Association for the Advancement of Colored People, NAACP, coming up and using litigation, and there are various cases that they supported, lawyers traveling all over the US to support cases and file cases. And then we see it, coming to light in the 1970s with the case of Brown versus Board of Education. Those that may not know this case, this was a case that was challenging discrimination in the education system. And for the first time, the Supreme Court annulled the principle of separate but equal, because it discovered it was being used as a pretext to promote discrimination. But it also made structural injunctions ordering states to make reforms and report back to court. So that's where the structural injunction was born. Then in India, the litigation is born mainly in the period between 1975 and 1977 during the state of emergency, where we see India going into a state of political anarchy, with civil and political liberties being violated, and people going to court to challenge those acts. But it has manifested mainly in India. It is manifested in the 90s and onwards, and it has continued to manifest as a struggle by the poor who need a certain level of protection than the rich. So we see so many livelihood-related cases. And what India did is that it birthed a number of principles that we see not only in litigation, but even in constitutions right now that facilitate public interest litigation. For instance, liberalization of the rules of standing, not following the strict doctrine of standing as is applied in the common law, procedure flexibility. For instance, if you look at our Article 126, that kind of procedure flexibility. There was a creative use of interpretation of legal and fundamental rights. For instance, extensively reading the right to life, include the right to a livelihood, and then remedial flexibility. So India contributed a lot, and the principles emerging from India were picked up by the South Africans. They put them in their constitution and also in their practice. The Ugandans picked a bit of it. Now the Kenyans came and picked everything that South Africa had picked from the Indians, but the Kenyans also added other provisions as well. Now South Africa, history of racial oppression, Lynette should be in a better position to speak to this slide. If I had time, I was going to hand it over to her. Social movements and the struggle for racial, the struggle against racial discrimination. But we also see people that were using the law. For instance, the Legal Resource Center. Those of you who may know it, the Legal Resource Center was using the law to fight against racial discrimination. And then 1995, a new constitution, which is which has progressive provisions on economic, social, and cultural rights, and the court has since been contending with issues of operation. I should have put Kenya here as well on my slides. I will add Kenya. Kenya has now also become a powerhouse because of its constitution and the jurisprudence that has arisen from Kenya, boldly contending with questions of resources, for instance, and saying, you see, resources, lack of resources is not an excuse. If it's going to be a defense, the following have to be brought in evidence by the court, by the state, and then Kenya also concretizing the rights of vulnerable groups, including those that have previously not featured, like youth, PWDs, children, extensively defining the rights of these groups, including the rights of the elderly. That's what Kenya has done. So, Lynette, are you happy now with that crash of the history?
Yes, thank you. Please skip anything. Like people are sending us very, very nice feedback. So it's like, no, don't skip anything, but please do go ahead. Thank you.
All right. So that's the history now. Now, what we have, and we need to be mindful of this as we move to use this form of litigation, is that we now have new forms of appeal versus the old forms of appeal. Now, the traditional forms of appeal, of course, away from the civil, they take the form of civil cases. It is usually taking the form of civil cases. It takes the form of constitutional litigation, either under Article 50 in our case, or under Article 137. It could also take the form of litigating before international mechanisms, including the international treaties, treaty bodies, or the international courts such as the East African Court. But there are new forms of appeal that have arisen. And as we litigate land rights, we need to be mindful of this. And I put the examples on that slide. The amicus interventions, including, Lynette, have you told these people that I'm the father of amicus in Uganda?
I haven't. And do you mean the father of amicus hotel, or also the father of amicus curiae applications? Yeah, everyone, we can host our meetings at amicus hotel.
They should know that I'm the father of amicus, so I can speak to that for a whole day. Private prosecutions also emerging as a form. I also consider myself to be an uncle of private prosecutions to a certain extent. And then, of course, also using individual cases. You can also do an individual case, but in a strategic manner that it's actually addressing a public interest matter and a matter that affects a larger group of people. So we need to be mindful of those new forms of public interest litigation and to embrace them, because some of them are effective depending on the circumstances. Context in Uganda, let me first skip that, but the legal framework, Article 50, we know. I'm not going to waste a lot of time on that. Article 137, we know. I'm not going to waste a lot of time on that, but I'm going to spend a bit of time on the question of the jurisdiction of the courts. And for a long time, this has been an issue. Which court has jurisdiction in a particular situation? Is it the High Court under Article 50? Is it the Constitutional Court under Article 137? This has always been a big issue. It has always been a big issue. Is anyone aware of how this issue has manifested? Anyone? Anyone with any views on
Yes.
how this? Yes. Please share.
Yes, Professor. So I will speak to my experience with the strategic litigation cases, some of which we have been doing here, where the Human Rights Enforcement Act actually has rules, and particularly I think it's Rule 7D of those rules that comes in to say, so despite the authorities that we have that settled the question about jurisdiction of High Court versus jurisdiction of the of the Constitutional Court, which basically allows, which basically indicated that the High Court will have jurisdiction to determine cases where the Constitution is, you seek to enforce the Constitution or particular provisions of the Constitution, as long as there is no interpretation that is required. So the Human Rights Enforcement Act, then under Rule 7D, then comes in to say that where a matter is a public interest matter, then it is the Constitutional Court that should have original jurisdiction over that matter. But when you look at cases for human rights enforcement, a big number of them are actually, like even when it's an individual case, it will many a times have an issue that affects the public. So for example, when we filed the case challenging the failure of the state to put in place a law on cohabitation, we had our individual client. But one of the AG's response, he highlighted that this is this issue of cohabitation is a public interest matter, and therefore the High Court actually doesn't have jurisdiction as per Article 7, rather Rule 7. And then I think that was the same stance that was taken again by the High Court in a case of legal. I think I could tell that they were relying on Legal Brains Trust versus Attorney General, where a case was dismissed on the same ground that it is a public interest matter. So under Rule 7D, it is the Constitutional Court that has jurisdiction. Rule 7D of the Human Rights Enforcement Rules is the Constitutional Court that should be having jurisdiction. So you find that for as long as your case, even a case on enforcing environmental rights issues, for as long as it has an aspect to do with the public, that you can call this a public interest issue, the High Court will almost certainly say this should go to Constitutional Court. Of course, it is yet to be tested whether the Constitutional Court, with now the Human Rights Enforcement Rules of 2019 in place, whether they would also then say go back because, well, the Constitution is supreme and superior to any regulations of the human rights enforcement rules. So go back to the High Court. We are yet to test that to see. But for me, my view actually is that that particular rule of the human rights enforcement rules should be challenged. In terms of constitutionality.
This is an area where the jurisprudence and the law is so jumbled. And you see, this jumble has unfortunately endured for a long time. From 1997, we've seen this jumble in the jurisprudence of especially the Constitutional Court. The court itself has not been coherent. Sometimes it allows cases that on the face of it appear to rhyme with its definition of enforcement. In others, it refuses to hear those cases. So it's an area that has really been jumbled, and I'm happy that you picked it up. The Human Rights Enforcement Act tries, but it has its limitations. But the Human Rights Enforcement Act is important as a tool for public interest litigation. These are some of its features. It allows anyone alleging violation of the human rights to approach a competent court for redress. It finds a competent court, this time to include the magistrate's court. That has not been the case previously. It clarifies the procedure. The procedure will be clarified. The rules, regulations, there are regulations out. Although those regulations you are referring to are not necessarily arising from the Human Rights Enforcement Act. We don't have regulations that have been adopted under the Human Rights Enforcement Act, because the ones that you refer to, the 2019 regulations on fundamental freedoms, So there is need to reconcile those two forms of regulations. The Act defines the jurisdiction of court, high court, magistrates courts, etc. It's in section 9. It's extensive on the kinds of remedies that may be decreed. It details them: compensation, restitution, rehabilitation, satisfaction, and any other remedy. But one of the most progressive provisions of this act is section 10, which imposes personal liability. Personal liability. I'm not sure whether very soon, I think very soon, Attorney General is going to challenge this in the same way he's challenging that provision that allows proceedings that have been where there is evidence in criminal proceedings that the person has been tortured. So personal liability under the Act, so that's an important step. Then also the fact that the law now expressly in section 13 addresses the question of progressive realization, and it imposes somehow picking from the Kenyan constitution, it imposes on the state the obligation, it says a person who has reason to believe that the state is not taking adequate steps for progressive realization can litigate. And then it defines what the court is supposed to do in 2. You may want to look at those provisions. What I want to concentrate on in the last 20 or so minutes that I have, because I think I'm going to use some 15 minutes, then I'll leave some 10 minutes or so for discussion, is the question of case identification and preparation. As we go into using litigation, how do we identify the cases to litigate? Land rights cases in this case. But the conversation we are having here is broad. It applies to other forms of cases as well. And first of all, we need to note the statement I have put up there, that emotional or spontaneous selection of cases can result into litigation of bad cases, or even cases which neither add value nor address real issues. So we shouldn't do cases emotionally or in a spontaneous manner without proper reflection, without proper preparation, without proper agenda definition. And we can't do that if we don't prepare. So one of the golden rules is prepare, and not preparing is preparing to fail. So prepare, it has been said, for you to do litigation effectively, you must prepare, prepare, and prepare. 3 times, prepare, prepare, and prepare. Very, very important. This is what Michael Flannery tells us regarding the golden rule: prepare, prepare, prepare. And he says, having a case settled in your client's favor does not occur by chance or luck. It requires preparation. Preparation in litigation is not something that begins and ends. It is a continuous tool throughout the litigation process. Every piece of evidence that is discovered and motion that is filed may change the strategy in the case. And every change in strategy requires new preparation. There is never just one strategy to follow. An advanced litigation strategy includes being prepared for any possible outcome, including litigation and settlement. So the importance of prepare, prepare, and prepare. That large case of yours, prepare and prepare. That eviction of yours, where we are looking at many people, prepare, get the evidence, document what has happened to the people, get the names, understand who the perpetrators are, understand the effects, get the history of the case, understand the law, how has the law evolved, how has it changed, understand the global context. There is a lot to do, which you cannot do if you don't prepare. Prepare, prepare, and prepare. Case selection. How do we select cases? Case selection. How do we select cases? What are the considerations? Again, remember I said, don't be spontaneous, don't be emotional. In other words, be deliberate. You have to be deliberate. For you to be deliberate, you have to reflect on the object of your litigation. You have to reflect on the object of your litigation. What do you want to achieve? What is your goal? What is your vision? This world, I usually tell my students, this world has so many problems. You cannot be the solution to all the problems of this world, but you can be a solution within the context of your objectives. You can provide solutions within the context of your objectives. So ask yourself, what do I want to achieve? What is my goal? What is my mission? So whatever you do in terms of preparing the case must be formed by your goal. Are you looking at widows' rights, for instance? So when you go in to do a case, you are looking at widows' rights in that eviction. Are you looking out for women affected by land grabbing? Are you looking out for a specific community? Are you looking out for how this particular land matter is affecting women? What are you looking at? Of course, you can be broad, but it's always good to be specific and to be particular. Are you looking at law reform, for instance? Is that what you are focusing on? That yours is to contest the law and annul provisions of the law that perpetrate violations? What do you intend to achieve? You can align this for those that are working in organizational settings. What is your strategic plan? Many times we adopt strategic plans as a perfunctory activity, and then we do things that are not connected to our strategic plans at all. At all. We never even look at it, but we usually submit it when we are fundraising. Isn't that what we do? How many of us here are guilty as charged? Please reflect on that. But the point I'm making, litigation has to be deliberate, with a clear object. When you begin the preparation, research is key in determining issues to litigate. You cannot litigate without research. How are you going to litigate when you don't even understand the context that I started with? How are you going to litigate if you don't even want to read? All you want to do is to call colleagues and put in WhatsApp groups. Does anyone have a precedent for a plaint on this? Please, please, please. And then you get that precedent and just change the names. Then when it comes to submitting on the case, you crash. You crash badly because you don't want to do research. And these manners of not wanting to do research start from law school. Of not wanting to read start from law school. So please, if you have those manners from law school, it's time to repent, reform, redeem yourself, and understand the importance of research. We need to research and understand. Again, Flannery helps us on the purpose of research in his publication, How to Develop a Winning Litigation Strategy. He says, in deciding cases, judges want a clear and concise legal basis for deciding a case one way or the other. The litigator who offers the court the simplest and most organized reasoning that supports the court's holding is usually the one who wins. The only strategy for out-simplifying and out-organizing your opposing counsel is to do comprehensive legal research. It is not enough just to have favorable case law on your side. It must be presented in an organized and easily digestible manner that helps the court support its holding with simple and sound reasoning. You cannot do this unless you do your research. Prepare, research. In your research, these are some of the questions you should address before you decide to draft those pleadings, before you decide what court to go to. First of all, your research should help you understand what the problem is. What is the problem? What is the problem? It's an eviction. It's a land grab. It's a dispute over land. It is extinguishing of existing rights. It is extinguishing of rights of Vibanja holders. It is a dispute over minerals. It's a dispute over the assessment of compensation. Understand your problem. Once you've understood the problem, your research should be able to help us understand who is affected and how. In other words, you're now trying to understand your clients and whether they have a cause of action. Who is affected and how? Document the impact. Who is responsible? Who is the perpetrator? Is it the state? Is it a state agency? Is it an international entity? Is it individuals? Is it security agencies? Is it community, another community? Is it local leaders? Who is responsible? Your research should be able to help you. So have that question deliberately in your research. What is the law, both international and domestic? Read the law. There's a lot of reading to do there. There is a lot of reading to do for you to understand not only the domestic, but also the international law. Your research should also be able to advise us whether anything has been done about the problem. Has anything been done? Has there been litigation? Have there been administrative processes? Has there been an international report? Has there been a media coverage advocating for change, etc.? If nothing has been done, can anything feasibly be done about it? Has the matter been litigated before? In your research, deliberately determine, is this a matter that is ripe for litigation? Is even litigation the best option? There are cases where litigation is not a good idea. Sometimes lawyers don't want to believe it, but there are circumstances where litigation is not a good idea. Actually, there are cases where litigation may do nothing but result into a bad precedent or jurisprudence that will negatively affect the community you are trying to protect. And then determine what's the best litigation strategy. What is the best litigation strategy? In your research, deliberately canvass feasibility of the case. Is the case feasible? You now know the facts. You now know the victims. You now know the perpetrator. You now know the law. So you assessing the case based on those parameters arising from that. Is the case feasible? But it is also the case feasible practically. Are the courts there? Are the courts willing to entertain the case? What are the attitudes of the judges towards cases of that nature? What do the precedents suggest? Understand comparative perspectives. Have cases of this nature been litigated elsewhere before? What have other courts said in other jurisdictions, comparative jurisdictions on similar cases? What is the appropriate forum? Is this a case for High Court? Is it a case for Constitutional Court? Is it a matter that can be resolved in the Equal Opportunities Commission? Is it a case that actually requires an international tribunal? Determine that, and your research should be able to canvass both things. What is the required evidence? And what is the role of the victims? And moreover, who has the evidence? How is the evidence going to be handled? And then what are the possible remedies? Colleagues, is this making sense? Are you still with me?
Yes, we are. It's making sense.
Yes. So research should canvass all those things. So meaning, you should have detailed research that then guide you. If you do that, you invest a lot of time in research, that should guide you. That should enable you to pursue your case seamlessly or to prepare for any eventualities. Okay. Let me quickly also run through this case preparation. I need a lot of time. I've run out of time. Case preparation, what are the considerations? Some of these issues are covered. Once you've done the research, case preparation becomes easy because it is informed by research, just as I say here, informed by the research from which the following could be determined, the issues to be litigated, the forum, the respondent, the resources required, the timing, appropriate forum, required evidence, possible remedies, likely impact of the case, possible challenges and barriers, resource implications, required partners and their role, strategic options of pursuing the case. So each of those is important. But as you do prepare for litigation, also it is important to assess your capacity. Assess your capacity. This is key. It's a key consideration in case. What are some of the factors one should consider is the question then. When assessing your capacity, you consider these. Do you have the financial resources required to pursue this case. You are going to go against a big corporation, Total. You are suing Total for an eviction. Do you have the financial resources to file and pursue? Do you have the required expertise, legal and otherwise, and other forms of expertise? Do you have the logistics available? Do you have the time, or are you committed to other things? Why would you file a very complicated case when you are in the middle of a reporting cycle on so many projects and everybody in office is busy preparing reports, urgent reports? So do you have the time? Is the timing proper? What is the evidence that you need? What is the evidence that you need? Determine that. How are you going to handle witnesses? We've seen cases where witnesses are endangered because they have been exposed by NGOs that are preparing cases. They put their faces in the media, and then after 2 weeks, you hear that witness disappeared, or we can't find the litigant, or the litigant is in detention. How are you protecting the witnesses? Do you have witness protection facilities available if they are required? Some cases are so sensitive that you actually need to be deliberate on witness protection. And then nature of evidence required, etc. I've run out of time because I want us to leave. Lynette, I think you now see that I need another CLE. Don't I?
I fully agree. Like, I don't feel like we should stop here. We are all good.
Yeah, there's quite a lot. I don't think I can cover what I have. I usually do this in a full day.
Oh my goodness. Yeah, because we're also just really like warming up. Like, I don't know if you have any more time to give to this
No,
today, if you're not rushing up.
Unfortunately, I have another commitment. I have to rush.
Okay.
At 11, I have to go into another meeting.
Okay, so then we have to say goodbye to you.
I would have also loved to discuss with you what happens after the judgment. When successful, what do you do? You try to digest the gist of the case. Implementation, how do you go about implementation, possible actors, dissemination plan, etc. And then what happens when you lose? You must have a plan B, plan C, or even plan D. How do you, if you lose, still you have to digest what lessons have you learned, what are the benefits that have emerged from this case that you've lost. So there is quite a lot. So Lynette and colleagues, what I didn't want to do, because I would have done this CLE by coming to you with principles that have emerged from land cases. In this case, it was held. In this case, the court relied on this, but that one any lawyer can do, even you as you prepare for the cases. But there are these skills of case preparation that people don't have. So that's why I chose to focus on those skills of case preparation. I've not looked at all of them because of time. I will have a conversation with Lynette later, and then we can see how best to complete this conversation. Because I also have another presentation where I do litigation strategy development. How would you develop a litigation strategy? What is a litigation strategy? Many times we speak of a litigation strategy, but what's a litigation strategy? What is a litigation plan? Here, I have case pursuit plan. You need a case pursuit plan. How does it look like? What should be in that plan? Lynette, I see we have 13 minutes. For now, I'm going to leave it at that and open up for any questions, for any comments.
Omeka.
Oh, I have questions. I'm going to ask them really fast in the interest of time. So my first question would be, when we were talking about public interest litigation, something that I would like to ask the good professor is, when it comes to class action suits, they are a form of public interest litigation, I would suppose, or I think. But when it comes to them, and you know the problems with class action suits, you have to, all the things that are in the law that you literally have to fulfill. For example, I'm so sorry about my background noise. Can you still hear me, or I change the position?
Yeah, please proceed. Proceed.
Okay, so with these class action suits, you have all these things and all these rules you're supposed to do. How is that physical? When we visited Chitezi, there was, you could see all this and you're thinking, is a class action suit really going to happen here? Because by the time, some people have been taken by Red Cross, some others have on this side. So by the time the lawyer that is interested even in helping, so for me, public interest litigation, as we know it, there are aspects of it that can work, but the one that may really need to help the person that needs it the most. Because imagine if you were doing a class action suit for Chitezi, tracing all those people, it was a mess. That's really all I can say. Then,
Sure. And that's why public interest lawyers have run away from representative class actions, because of those complexities. Omega, we are losing you.
it's a question
We are losing
of
you.
internet issues. But my second one, can you hear me now?
Yes.
Can you hear me now?
Yes.
Can you hear me now?
Okay. I think Omega has issues, but you
Can you hear me now?
we hear you, but you keep breaking.
Okay, I hope I'm now a bit more steady.
Yes, but I've taken note of your question regarding class actions, and I was saying that's why public interest lawyers avoid those, because of those complexities. They are also very technical. It can fail because of a technicality, which is not the case for forms of public litigation.
Okay. I think now you can hear me better. My second question to you would be that we have a project in Fort Portal right now, and you know Fort Portal, there is going to be a lot of petroleum extraction. What would be your thoughts on that? What things are you foreseeing in that area? What would be your advice to the team that is in that area? Yeah.
Okay. All right, I've taken note of that. I think there's need for one to get the details of that project. Probably we can have a conversation on that later. We can get in touch. I see Joy. Joy.
All right, thank you so much, Professor, for this session. Now, you said you're almost the uncle of private prosecution in Uganda, but I also remember you in the Kale Kaihura case and how it ended up. But now my question would be on the sub judice rule. I remember one of the things you talked about was advocacy for and advocacy after. Then advocacy for, how do you reconcile this and the sub judice rule, especially, I didn't mean to mention names like Justice Sekana, who really doesn't like advocacy before the case is filed or when the case is ongoing, but also looking at countries like Ghana, where it's really a strong rule where if you have, if a case is being litigated and you're talking about it, the judge would actually strike it out.
Prison. Yeah, in Ghana, you even go to prison. They send you to prison.
So I am just wondering, what would be the remedy for that, but also on private prosecution and the takeover by the DPP? I know this has been a really key issue in appeal matters, but especially in criminal cases. How do we manage this particularly now, especially? This could be land, but also there's something called SGBV, where I feel like sometimes that DPP mishandles cases. And if they were privately prosecuted, maybe would have better precedent, better laws, better judgments. So as the father of or the uncle of private prosecution, how do we reconcile some of these things? And then the sub judice rule, I really want to hear you on that, especially advocacy before.
On the sub judice rule, my personal view is that that rule is unconstitutional. It stifles freedom of expression, but it's also pretense. At the end of the day, judges get to read about the case in media. It has even become worse with social media. It's no longer feasible to enforce the sub judice rule, but strategically, you can navigate around it by doing it in such a way if you are working especially in a coalition, in a network of organizations, in a group, you make sure that the people litigating are not the people talking about the case. Sometimes as lawyers, we get temptations to go to the media. But if you are the lawyer doing the case, you should avoid that. But if you are working with organizations and the organizations which are not even illegal, they can do that. I would have spoken about that if I had time to speak about the case pursuit plans, because that is something that I cover on how to share roles and responsibilities. And sharing roles and responsibilities could be done with the consideration of the sub judice rule. On the question of the DPP taking over, again, just to inform you that 2 weeks ago, we were able to convince the High Court, a magistrate's court in Mubende, to stay prosecution of the criminal case and to make a reference to the Constitutional Court. We are challenging the DPP's power of takeover. We are saying that the proper reading of the law should be such that the takeover should be with the leave of court and with the involvement of the private prosecutor. So just be on the lookout. Just 2 weeks ago, we got a referral. So we are going to have a petition in the High Court, the Constitutional Court, to argue that provisions of Article 120, provisions of that the practice of the DPP taking over contradicts, is inconsistent with provisions 120 of the Constitution, as well as Article 43 of the Constitution. 46 rather, I think I need to be sure. Yeah, so that is something that that is coming up. Okay, any other? I have 5 minutes, Lynette, to be out of here.
Speak now, small window of opportunity remains. All right, I think we are done asking our burning questions. But Chris, thank you so much for being with us this morning. It has been an incredibly engaging training, and we all wish it could have been much longer. I think we really need you for like a whole week training. It's like I feel that we've touched the surface, but there is so much to learn from this combination of your practice experience as well as your your teaching capacity to really be able to train lawyers and to follow in your footsteps. So thank you for making the time and to invest in the CLE training, to invest in the FIDA lawyers and FIDA members who were with us today. We feel that this was really just the beginning. We really would love to engage you for future more in-depth trainings, collaborations on our civil cases. And we are very, very grateful. Let's give him a virtual hand, everyone who has hands. And so as we've ended the training part and the teaching part of our training today, I'd like to direct your attention to the chat.
Okay, thank you.
Yeah.
Okay,
Okay, bye-bye, Chris. All the best.
Thank you.
And please take a look at the chats. There you will find a link to your take-home assignment. So this is an assignment where you're expected to submit written work to us between 1,500 and 2,000 words, responding to the questions. And we are requesting that you kindly submit this by 3 p.m. today to myself and to Kathleen Alice over email. And kindly note that this is a requirement if you wish to earn CLE points for your participation in this training today. We expect you to submit this. We will send you a acknowledgement of receipt once we have received your assignment. But please take note that we will not be able to award CLE points to anyone who has not submitted and completed the assignment. So on that note, we can actually say goodbye. We will leave the room open so that anyone who joins in later sees that we are doing an assignment and that is what is expected of them. But thank you very much for joining us today. I think you can also really agree that it was not long enough. Usually 2 hours can feel very, very long in a training, but today it just flew past. And I hope you also feel that you've really benefited from this training, if nothing else, to really just make you more curious and more interested in strategic interest litigation, which I feel that has truly done for me. Are there any questions or any concerns before I say goodbye?
None really, except thank you, Lynette. Thank you, Alice. Yeah.
Thank you so much, Ameka, and everyone. And yeah, have a lovely rest of the afternoon. And we will be in touch about our very last CLE training for the year that will take place next month, and with Lydia Buite from Platform for Labour Action. All right. Goodbye, everyone.